Down the transparency and accountability rabbit hole, cries for transparency and accountability in family courts are prevalent around the globe. This is understandable since custody cases are often shrouded in secrecy, with courtrooms closed, mothers gagged, and records sealed, all while judges and their lackeys have little accountability for their corrupt and discriminatory conduct. But it begs the question, will more transparency and accountability make any significant difference in the custody crisis? Or is promoting these solutions just more distraction and diversion from what will truly end the scourge of mothers losing custody? That is what we'll be delving into in this latest segment of our Rabbit Holes series. This Women's Coalition series includes the domestic abuse, parental alienation, cottage industry, court appointee, gender neutral, rights and laws, and training and education rabbit holes. The series is accessible from the menu bar and in the archive. The purpose of the Rabbit Hole series is to help mothers and the public understand the true nature of the crisis. Common false narratives are addressed in the series which must be dispelled and replaced with true ones. The goal is to unite women under a true set of facts about what the crisis really is, why it is happening, and what will end it once and for all. See takeaways. The two branches in this rabbit hole, transparency and accountability, are interrelated. Transparency serves as one form of accountability. So, we'll begin with accountability. The accountability branch. There are 5 main ways judges could theoretically be held accountable. 1. Appellate courts is theoretically the only legal avenue to hold judges accountable for unjust decisions in custody cases. But family court rulings are appealable under the most deferential standard of review, abuse of discretion, meaning they are the hardest to overturn. Appellate justices virtually always rule a judge is within her or his discretion. In the rare cases in which a custody ruling is overturned, it is usually just remanded back to the same or new judge who easily finds another, more discretionary way to keep the father in control. Judges often brazenly challenge mothers in open court, "If you don't like my ruling, take it to the appellate court." Knowing that will do nothing but drag the case on for years, which supports the agenda. So, appellate courts are expensive, time-consuming, and ultimately useless in holding judges accountable. 2. Judicial commissions provide another theoretical way to hold judges accountable. Judicial conduct commissions address ethical violations, like bias, corruption, and conflicts of interest, misuse of judicial office, like favoritism and retaliation, criminal behavior, impairment, like mental illness and substance abuse, and failure to follow laws or judicial canons. If misconduct is found, the Commission can impose actions ranging from a reprimand or continuing education, i.e., slap on the hand, to suspension or removal from office. But it is extremely rare for any serious discipline to be meted out to family court judges, much less a significant enough punishment to hold them accountable or to make any difference in a mother's case. After all, members are part of the power elite, just like the family court judges they supposedly oversee, and thereby uphold the father entitlement prerogative. Judicial commissions are just as rigged against mothers as family courts. Third, licensing boards are the equivalent of judicial commissions for family court affiliates and appointees. They theoretically provide accountability by regulating the conduct of legal and mental health professionals assigned to custody cases. These boards handle complaints against attorneys, psychologists, therapists, and social workers involving ethics violations, misconduct, and incompetence. Mothers may file a grievance against their children's attorney and their own attorney with state bar associations. Complaints against mental health professionals may be filed with state boards of psychology, also called boards of behavioral health. Licensing boards have about the same success in providing accountability as judicial commissions, close to zero. But the core problem is that judges should not be able to appoint anyone, ever, or for that matter, not have anything at all to do with the case other than making sure the law is upheld and due process afforded to litigants, as happens in a real court. 4. Disqualification is another way mothers can theoretically hold judges accountable. However, the motion to disqualify goes to the judge the mother is trying to disqualify. Of course, the judge is not going to admit that he is biased or corrupt and grant the motion, unless it is causing other problems, and that he wants off the case, such as bad publicity. Sometimes you can ask for another judge to review the motion, but that is likely one of their buddies, who will simply dismiss it. So, this process is a dead end as well. 5. Lawsuits are the most theoretical way of holding judges accountable, since suing judges is prohibited by the doctrine of judicial immunity. This applies even if the decision is malicious or there is legal error. And this immunity is not so coincidentally extended to court appointees, who are instrumental in deflecting blame from judges, often referred to as derivative or quasi-judicial immunity. The reason given for this generosity is that they are acting in a judicial capacity. Right. The truth is, these lying actors assist judges in switching custody to fathers and deflect blame from them. The idea behind Mother's Cries to end judicial immunity is that if judges could be sued, they would be less likely to make bad rulings, but it would more likely work in the father's favor. Judges would be more fearful of being sued by men's attorneys than women's. However, there is no realistic way to overturn the doctrine of judicial immunity, which has been around since the Magna Carta. So the common cries to end it are a waste of breath. Hence, all forms of accountability in the family court system are not so coincidentally theoretical. All doors marked justice are dead ends. But what about transparency? The transparency branch. Mothers' cries for transparency are as prevalent as for accountability. That is understandable, since the glaring opaqueness of family courts makes it seem like that is the problem. Family courtrooms are either closed to the public by default, as in the UK, or can easily be closed if a judge is annoyed by public attention to a case. Even if the courtroom itself is open, judges can still seal records and gag mothers. They override mothers' right to free speech by deeming it in children's best interests to keep family matters private, the age-old mantra helping to cover up men's abuse in the family. Even where courts are open, MSM is discouraged from following cases through other tactics, such as continuing cases endlessly, waiting until the attention dies down. Also, MSM is loath to put blame where it belongs, on the judges and the system. There have been plenty of examples over the decades that open courts and freedom to speak about cases will not make much of a difference. There are lots of mothers who've gotten a ton of public attention, whose children were never returned. Having said that, public pressure can help to keep the worst from happening. Bottom line is, judges will choose short-term bad publicity for long-term gain. By towing the line, they get a warm seat at the old boys' table, replete with promotions and other kudos. Takeaways. When women gained the power to easily divorce husbands a half-century ago, and divorce they did in droves, the old boys were no fools. They knew their most coveted patriarchal prerogative, control over their women and children, was threatened, and they had to act. Hence, the family court system was created in the image of man. The old boys made it as opaque as they possibly could in a functioning democracy, justifying it with the private family matters mantra and extending that to be in children's best interests. Additionally, they made it virtually impossible to hold judges accountable in any meaningful way. They were way ahead of unsuspecting women who believed they had fought successfully for equality. They had no idea what the old boys were up to. They naively thought family courts were real courts, where they would be afforded due process, and justice would prevail. They could not have been more wrong. For over a half-century now, family court judges have gotten away with switching custody from loving, primary nurturing mothers to abusive, self-serving, and molester fathers, with little public awareness of their evil endangering and traumatizing of children. Hence, the prevalent and impassioned cries of transparency and accountability. To be sure, totally open family courts and an effective means of holding judges accountable would be far preferable to what is going on. But here's the important takeaway. That would not end the custody crisis. It would just make it a bit more difficult for judges to do the dirty deed. The truth is, the family court system itself is the problem. It is deliberately rigged from the top down to entitle and empower men, and no amount of piecemeal reforms will stop judges from taking children from mothers and endangering them. The fish rots from the head. Focusing on trying to plug the leak in the Titanic with gum distracts and diverts from understanding what is causing the crisis and what will end it. The cries for transparency and accountability should be replaced with get custody cases out of family court and into a real court with a jury. Join the women's coalitions where we are demanding a new system where judges do not have the power to take and endanger our children. In other news, Chapter 1 is out. We've begun a new novel about yet another mother's family court nightmare. Sections will be published weekly, so be sure and subscribe to our Substack and you'll receive them in your inbox. Discrimination lawsuit. We're getting ready to file our discrimination against women in family court lawsuit in New York. If your custody case is in New York, or you know mothers whose case are, be sure and ask them to join. Thanks to all NY mamas who've already joined. You will be contacted soon with updates. We will hopefully be filing in other states and countries following the New York lawsuit. The lawsuit claims it is systemic discrimination that is causing women to lose custody, that family court judges are violating women's right to due process and equal protection on a systemic level, because they are women. If you are a woman who's lost custody in family court, you may join our lawsuit. And that's our news and views for this week. Please subscribe, like, comment, and share so this important information is spread far and wide. And if you are able, please consider contributing to our important work of ending the crisis. The information is in the description box. Thanks and see you for the next custody crisis stories.